Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 77. In this podcast we've got the usual roundup of recent cases. The first case considers whether it's possible to make a claim of associative indirect discrimination. The key question that the ECJ has to consider is whether, despite not being from the same ethnic or racial group as the disadvantaged group, the individual could claim indirect race discrimination on the basis of her association with that group. Secondly, we look at the most recent holiday pay case, focusing on employees on sick leave and whether they are entitled to carry over their accrued but untaken holiday. I always think it's nice for the courts to determine holiday pay cases during the height of the summer holidays. Thirdly, we have an EAT decision which considers when an employer's duty to collectively consult is triggered and the special circumstances exception to that duty. Then finally, by way of reward for sticking with me through to the end of this, I've got a couple of recommendations out of the WOMAD music festival that I went to just recently. So the first case has an utterly unpronounceable name. I don't think I've ever come across one that has such an unpronounceable name. So I'm just going to call it the RBA case. And it is basically to do with Bulgarian electricity meters. So if you think of it in your head as the Bulgarian electricity meters case, we won't go too far wrong. So this is an ECJ decision looking at whether the individual could claim discrimination under the Race Equality Directive by virtue of her association with a group that was disadvantaged by a provision, criterion or practice. In this case, the individual was not of the same ethnic or racial group as the disadvantaged group. Although the case it's actually an employment one, the ECJ considered the same definitions of direct and indirect discrimination as apply in the employment law arena. The current position under UK legislation is that indirect discrimination is only established under Section 19 of the Equality Act if the individual has the same characteristics as the disadvantaged group in question. The Equality Act does not provide protection in the circumstances of associative indirect discrimination. Therefore, it's not unlawful under the Equality Act for a person to be disadvantaged by a PCP due to their association with a person who would have had the protected characteristic. In this case, the CRB provided electricity to a district in Bulgaria that was predominantly inhabited by people of Roma ethnicity. In this district, the electricity meters were fixed at a height of approximately 6 metres off the ground. In other districts, the electricity meters were fixed at about 1.7 metres off the ground and were often located in the user's property. This enabled the user to monitor their electricity usage against their bills. The CRB explained that the reason for the height difference was there had been incidents of reported tampering with the meters and unlawfully connecting to the district's electricity network. The claimant owned a shop in the 6 metre high district. She claimed the Roma people were disproportionately affected by CRB's policy. Although the claimant was not of Roma origin herself, she suffered the same disadvantage. The Bulgarian court ruled in her favour, concluding that she had been subject to indirect discrimination on grounds of ethnicity. As a result of the location of her shop, she had been treated less favourably by CRB than customers in other districts. The court held that it was unlikely that CRB's policy could be objectively justified. CRB appealed the decision to the Bulgarian Administrative Court, which in turn referred certain questions to the ECJ. Amongst them was the question as to whether this policy was direct discrimination or indirect discrimination. Secondly, even though the client was not of Roma origin or ethnicity herself, could she claim that she'd suffered unlawful direct discrimination or unjustified indirect discrimination if she was adversely affected by the policy? Pausing there, the key issue for both the direct and indirect discrimination claims was the fact that ultimately the client identified herself as being of Bulgarian ethnic origin. There was a point earlier on in the case where she talked about associating herself with Roma by identification. But she clarified this, as I say, to say, no, I'm Bulgarian ethnic origin. And so she was saying that she was a victim of a policy decision by CRB, policy decision allegedly, directly or indirectly targeted the Roma. She suffered because of her association with the Roma, namely the fact that she lived in the same area of the city as a significant concentration of Roma people. Therefore, a key question in relation to the direct and indirect discrimination claims was whether associative discrimination claims were permitted. And just to emphasise, the associative discrimination claim is where the claimant themselves does not have the protected characteristic of a particular ethnic origin or disability, religion, etc., but is associated with someone who does have such a protected characteristic, and it is alleged that the claimant suffers by virtue of that association. Well, the Advocate General in the ECJ produced an opinion on the case before the ECJ provided its judgment in the usual way, and confirmed that non-Roma people in the district were affected by the CRB's policy by way of collateral damage. And she concluded that this was indirect discrimination, and that the concept of associative indirect discrimination applied in this case. Therefore, the claimant's claim could, in principle, succeed. Well, the ECJ took a slightly different approach. They confirmed that, in their view, the policy was directly discriminatory, even though it was applied equally to non-Roma living in the area as well as those of Roma ethnic origin. The policy, according to the court, amounted to discrimination on the grounds of ethnic origin if the measure was introduced or maintained because of reasons relating to the ethnic origin common to the majority of the inhabitants in the area. In other words, if the policy was designed to target those of a Roma ethnic origin, it did not cease to be unlawful direct discrimination merely because there are other individuals who were adversely affected but who were not Roma. Secondly, if it wasn't direct discrimination, the court said, then it was unlawful indirect discrimination, since it was an apparently neutral practice which put persons of a given ethnic origin at a particular disadvantage. The court confirmed that for these purposes, the wording of the directive which prohibits discrimination on the grounds of ethnic origin covered indirect associative discrimination, although I should make it clear the term was not used in the court's decision itself. Well, I think the case is potentially very significant, and it will be one that will have been followed closely by many claimant lawyers. It's been well established in the UK since the Coleman and Attridge case back in 2008 that an associative discrimination claim can be brought for direct discrimination. So the Coleman case, for example, concerned comments allegedly made about a disabled child to the non-disabled mother, and that gave the non-disabled mother the potential to claim direct associative discrimination. And the Equality Act makes this clear now. However, it's in relation to the indirect associative discrimination claim that this case is radical. Clearly, the distinction between direct and indirect discrimination claims seems to have been blurred somewhat by this case, and it's noticeable the Advocate General did not think this amounted to a direct discrimination claim. Obviously, stretching the concept of a direct discrimination claim to cover a policy introduced on grounds of ethnic origin, and which mostly detrimentally affects one group, but not exclusively, is to expand the definition of direct discrimination. And given that, generally, direct discrimination is not capable of being justified other than the most extreme circumstances, this is obviously quite a significant point. I wonder whether the key is that this original policy was, according to the court, introduced for directly discriminatory reasons, i.e. targeted at Roma individuals. However, it's in relation to indirect associative discrimination that the case is groundbreaking, and we will have to see how far the court is prepared to develop this concept, but it does look at the moment as if the Equality Act is now out of step with the UK's European obligations, and we can anticipate that words are going to be read into the Equality Act to get us back to the right solution. Under the Equality Act at the moment, it's clear the individual has to be a member of the protected group, disproportionately affected by the neutral provision criterion or practice. Now, individuals are going to still have to suffer a detriment personally for there to be a claim. The claimant in this case could not check her electricity meter because of the height at which it had been placed. In other words, it was not enough just to be living in this particular district to be able to claim unlawful associative discrimination. Here, the claimant was disadvantaged because she was unable to access the electricity meter to check her expenditure. This was the same detriment suffered by the Roma living in the area. And the analogy I think I'm drawing at the moment when I'm trying to sort of sort this out in my mind is that it's a bit like the piggyback claims that we see in equal pay cases. Under the equal pay legislation, if a woman is underpaid relative to a male comparator doing a different job, and the pay differential is not justified, then the woman's pay is levelled up to the man's. However, any men who were previously on equal pay to that woman can then in turn push their pay up to the new level, relying on the woman's new level of pay. Those are piggyback claims. Here, the logic of this decision is that if a member of Roma living in that particular area had applied and brought a claim for indirect discrimination, then it would have been successful. This case extends the net for individuals who are able to claim unlawful indirect discrimination. So when evaluating the risks of an allegedly discriminatory policy, if one is attacked, it's going to be necessary for employers to think carefully about how far such claims may go. I suspect we're still working out all the ramifications of this case, so it's definitely one to keep an eye on in the next few months. And one point I think is going to be quite troublesome is what's going to be necessary to show that a claimant who does not suffer from the particular characteristic is associated with a disadvantaged group. I'll give one example, and I'm sure this could be multiplied indefinitely. If I introduce a policy because I don't want female employees, that all my employees have to be 6 foot tall, that's clearly indirectly discriminatory against women, because the average female height is less than 6 foot and the average male height is above 6 foot, let's assume for the sake of argument. So as a man who comes along and who's 5'6", associating with women merely by virtue of the fact that his height is closer to their average height. We'll see. Anyway, that's the RBA case with the unpronounceable name. I should say, given that it is an unpronounceable name, the YouTube version of this has got the full case name on it. We will tweet out links to the cases in the usual way, which will go out when this podcast goes out. So hopefully those of you who actually want to work out, again, for all the families play at home, how to say this particular case name, you can then do so. Second case, much easier name, Plum and Duncan Print Group Limited. Well, this is the latest EAT decision to consider the much discussed topic of holiday pay. This time it's in respect of whether employees in the UK who have not taken their annual leave due to sickness are able to carry this leave forward into the next holiday year. Well, the position of the working time regulations is that a worker must take their annual leave within the leave year in question, in respect to which it is due. So, if the employer's leave year is between January and December, the employee must use all of their annual leave by the end of December. Equally, a payment in lieu of holiday cannot be exercised, save on termination of the employment relationship. However, this principle of non-carryover under the working time regulations was challenged in the case of NHS and Lana, which identified that the regulations were incompatible with the working time directive. However, Lana confirmed that where an employee was unable or unwilling to take their paid holiday during a period of sickness, they were entitled to take it at another time. But Lana did not deal with any time limit on how much leave could be taken over by an employee on sick leave. This is an area of focus for EAT in the Duncan Print Group case. So, when we're considering an employee's ability to carry over annual leave, just one point to bear in mind, we're only referring to the 4 weeks of annual statutory leave an employee is entitled to under the Working Time Directive. We're not talking, it's now clear, about the additional 8 days of holiday provided for under the Working Time Regulations, or any additional contractual holiday an employee may be entitled to. So, Mr. Plum had been off work for 4 years following an accident when his employment was finally terminated. He'd not taken paid annual leave for 3 of the 4 years he'd been off, but about 6 months before his termination, he'd asked to take 20 days paid annual leave in respect of each of the 3 holiday years, and this request was refused. Following the refusal, he claimed pay for untaken holiday for all of the 4 years. So the 3 he hadn't asked for holiday, and the 4th where he had asked and it had been refused. Well, the tribunal dismissed Mr. Plum's case. It concluded that the approach in Lana meant the employee had to establish that they were unable, due to their sickness, to take their holiday during their period of absence. Given that Mr. Plum had provided no such evidence and had continued to work indeed at another job during his sick leave, the tribunal dismissed his claim. Mr. Plum appealed to the EAT. The EAT considered 2 key issues in the appeal. First, was an employee required to establish they were unable, due to their medical condition, to take their annual leave in order to carry it over? Secondly, is there any limit in the UK on the period that an employee is able to carry over any accrued but untaken leave? Note, just before we go any further, that since this case was started, the law has now changed, and the provisions in the Employment Rights Act, which arguably permitted employees to claim back holiday pay indefinitely, in which the employee here tried to rely on, well, those provisions have now been limited to 2 years back holiday pay, I should say, under the deduction from wages limitation regulations 2014, which applied from 1 July 2015. I'll explain why this case is still relevant in a second. Well, on the first base, the appeal tribunal held that employees need not show that they were physically unable to take holiday because of their medical condition. In essence, an employee on sick leave can choose to continue to receive sick pay, or can choose to take a period of sick leave as holiday instead and be paid at the holiday pay rate. The employer cannot force the employee to take one or other option. Therefore, the employer's attempt at limiting its liability by demonstrating that Mr. Plum was perfectly able to use up his holiday whilst on sick leave failed. On the second point, the EAT held that carryover need only be permitted for a maximum period of 18 months, in line with European case law. The EAT's reasoning was elegant. It accepted that the working time regulations did not, at that point, provide a limit for the carryover required by European law. However, the court pointed out that the ability to carry over holiday was itself achieved by the court writing words into the working time regulations. It was clear the court should only write in such additional wording to the extent that it was necessary to comply with the directive. If case law under the directive had shown that it was not necessary to carry over holiday for a leave for a period of more than 18 months after the end of the holiday year in question, then that limitation could be written into the working time regulations too, as well as the principle of carryover. It may help to show what happened in this case to see how this actually plays out. Mr. Plum was on sick leave for 4 holiday years, which ran from 1 February to 31 January each year. So the 4 years, February 2010 to January 2011, February 2011 to January 2012, February 2012 to January 2013, and February 2013 to January 2014. He'd asked for holiday leave in the February 2013 to January 2014 holiday year, and his request was on the 5th of August 2013. He was then dismissed on the 10th of April 2014. Therefore, by virtue of the limitation, he'd lost entirely the holiday leave for 1 February 2010 to 31 January 2011. That right to carry over that holiday unused expired 31 July 2012, i.e. 18 months after the end of the holiday year in question. He lost the February 2011 to January 2012 holiday year because that expired 31 July 2013. He was entitled to carry over and therefore be paid out holiday entitlement for February 2012 to January 2013 because he requested that holiday leave on the 5th of August 2013, i.e. within the 18-month limitation period. He would also have a pro rata entitlement for holiday in 2014 which he'd not taken. Therefore, when he was dismissed, he was entitled to holiday from February 2012 to January 2013, February 2013 to January 2014, and pro rata for the time taken for holiday in the 2014-15 holiday period to the extent that he'd not already taken it. Given the law surrounding holiday pay is currently evolving and is quite high profile, the EAT gave permission to both parties to appeal. It's therefore likely this case isn't going to be the end of the matter. However, it does certainly seem to be a very sensible solution to the issue of carryover of holiday, because it does look as if the courts may set themselves against any suggestions that an employee can carry over unlimited amounts of holiday leave, even where the regulations don't apply to limit them to 2 years back pay. It's also, dare I say it, a very sensible approach for the court to take to say that the holiday, that an employee does not have to demonstrate that they were unable to take holiday, because one can see that could have all sorts of very fine distinctions, particularly if an individual was not working and was simply staying at home. After all, staycationing is not exactly an unknown phenomenon. Anyway, that's the case of Plum and the Duncan Print Group Limited. Final case, Ivor Hughes Educational Foundation and Morris. This is an EAT decision considering the trigger point for employers' collective consultation obligation when large-scale redundancies are proposed. This case looked in particular at the scope of the special circumstances exception to that obligation. By way of a quick summary, Section 188 of TALCRO requires employers to consult with affected employees with regards to any proposed redundancies of 20 more employees in a period of 90 days or less. Trouble is, it's not always easy to pick out the exact point in time when this obligation is triggered. There's been conflicting case law on this point, and in one case the EAT talks about the trigger point being where there was a fixed, clear, albeit provisional intention to dismiss. In a more recent case, the ECJ held that the duty was triggered when only a strategic decision has been taking place compelling the employer to plan for collective redundancies, which is something more than mere contemplation. In light of this, conflicting case law, frankly, the exact point at which the duty to collectively consult is triggered still remains unclear. Once that duty is established, an employer might still be able to avoid any such consultation by relying on the special circumstances exception and arguing it was not reasonably practicable for the employer to consult for the full period, or maybe indeed at all. Now, I would just mention at the start, you do not need to consult from the earliest opportunity. So sometimes the trigger date, it's quite all right not to consult at that point. However, if you leave collective consultation past the trigger date, you do need to be able to fulfil the obligations still, both the content of consultation and time-wise. If inadequate consultation occurs, it may then be very important to know at what point collective consultation should have begun to work out awards and so on. Well, in this case, a school operated by the Foundation was facing a decline in pupils. On the 27th of February 2013, a decision was taken by the governors of the school to close the school unless pupil numbers increased. At a subsequent meeting on the 25th of April 2013, the governors were informed the predicted pupil numbers for the following school year were even lower than expected. A decision was therefore taken to close the school at that point. The Foundation gave the staff notice of their dismissals, no collective consultation was carried out, and the employees brought claims for breach of Section 188. The Foundation admitted that it was not aware of its legal obligation to collectively consult. However, it argued that the trigger point for the purpose of the obligation did not occur until the meeting of 25th April. In any event, the Foundation argued that it was entitled to rely on the special circumstances exception, and it put forward two special circumstances. Firstly, that it could not have consulted with the teachers because the news of the closure would have leaked, which would have led to parents moving their children from the school and sealing the school's fate. Secondly, it didn't have time to consult because it had to give the teachers notice in April in order to avoid the requirement under the teachers' contracts of employment for a further term's notice. The Employment Tribunal allowed the teachers' claims. First, the Tribunal held that the trigger date was the 27th February meeting, not the meeting 2 months later. The Tribunal found that at the earlier meeting there was both a clear, albeit provisional, intention to close the school and a strategic decision on changes, compelling the employer to contemplate or plan for collective redundancies. On either analysis, the duty to consult arose on 27th February, not the later date. Secondly, the Tribunal found there were no special circumstances. It quickly disposed of the argument put forward, finding that firstly, the Foundation could have consulted with employees and emphasised the need for confidentiality, thereby to avoid any leaks. Secondly, the contractual argument for avoiding a longer notice period was not capable of amounting to a special circumstance. As a result, the Tribunal awarded the maximum protective award of 90 days actual gross pay for each dismissed employee. The fact the employees suffered no actual loss was not capable of being a mitigating factor to justify any reduction in the award. The Foundation appealed, but the EAT dismissed the appeal. It agreed that the Tribunal was entitled to find on the facts that the duty to collectively consult arose on the 27th of February. The same outcome could be reached by applying either of the two competing tests established in the previous case law. Also, the EAT noted the argument was purely academic because even if the duty arose on the later date, the Foundation still had failed to consult, so the Foundation would still have been in breach of its duty. On the special circumstances defence, the EAT agreed that this exception, this defence, did not apply. It took a slightly different approach. The EAT held that the circumstances put forward by the Foundation were hypothetical. As such, they were not capable of constituting special circumstances. The confidentiality and notice period reasons were not actually considered by the Foundation at the time of its duty to consult, as it didn't realise it had an obligation to collectively consult at all. The special circumstances exception can only be relied on where the circumstances prevailing at the time are out of the ordinary, making it impractical for the employer to consult. The employer could not rely on hindsight to justify retrospectively its failure to consult. In the circumstances, there was no exception which prevented the Foundation from complying with its duty to collectively consult, and the EAT therefore upheld the Tribunal's decision to make the maximum protective award. Previous case law had clearly established that the purpose of the award was punitive, not compensatory. The EAT agreed with the Tribunal that the Foundation's ignorance of the law arose because of a reckless failure to obtain legal advice, therefore it was not a mitigating factor, and the maximum award was justified. There may be some that think this decision is a harsh one, and certainly you would anticipate that once news leaked out that the school was in difficulty, there would undoubtedly be a rush for the exit. Nonetheless, I think the key lesson is that the EAT was unimpressed the school had not taken legal advice to establish what its obligations were in relation to its staff, and as a result, the school faced the maximum sanction. So that's the case of E. Ivor Hughes, Educational Foundation, and Morris. So, as a reward for staying with me to the end, I said I'd say just a few words about the WOMAD Festival, which was, first of all, great fun, and B, exceedingly wet. In terms of recommendations, one person who stood out for me, a guy I'd not heard of before, was a chap called Kim Churchill, who's an Australian singer, slightly bluesy, does some really good material, very good live performer, and anyone who throws in a cover version of Subterranean Homesick Blues is all right by me. So, Kim Churchill, tip for the top. You heard it here first, well, at least first on a podcast devoted to employment law. So thank you very much indeed for listening, and until we get to podcast number 79, stay safe. Thank you.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.